Good morning, everyone. This is the State on Purpose calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams. As you can see today, we will take care of several outstanding matters, including taking pleas, arraigning cases, and setting bonds. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney here today. All participants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means that any member of the public can log on and watch this particular proceeding. I'm going to ask that all members of the Public Defender's Office have the opportunity to interview and speak with their client.
Yeah, Judge.
All right, let's begin. Who do we have first?
Good morning, Judge. This is going to be position 6, Mr. Clark.
All right, the announcement I have is that a breakout is requested.
I was going to say for me, Your Honor, I've spoken to my clients, but there's a few individuals Mr. McLean would need a breakout session for, but I can proceed on some of my positions while he's doing that.
All right, so Ms. McLean, you're muted. You haven't had the opportunity to speak with your client.
All right, yes, Your Honor, except for, I believe that Mr. Guy, if it's pronounced that way, Clark, number 6, was outsourced, and normally they bring them into the jail area about 6 a.m. or 5 a.m. So I'll need a breakout with him, and I think there might be
Over there, Clark, at the,
Mario Berry. They didn't, they're kind of short-staffed, so.
Are you able to call the jail, Mr. McLean, instead of a breakout?
They could call me on my phone, either my desk or my cell, either one.
All right.
and you could just call our courtroom number. It's going to be 404.
Okay, hang on just a second. Okay, 404.
612-2392. 404-612-2392.
All right, that'll be for Mario Berry and Guy Clark. You know, and the announcements, I was just typing into chat on number 1 is a not guilty and a bond request.
Okay,
But
hold 1 second. Hold 1 second. I'm sorry, were you speaking with me, Mr. McLean, or you're coordinating with the jail to speak with your clients?
no, I've already talked to position 1 and 2, which is one person. And the announcement on that is not guilty bond request.
All right, who are we taking next to courtroom 2?
Position
Uh,
8, Mr. Cooper. Come on, Cooper.
Let's see, Mr. Cooper is a negotiated plea, Your Honor.
All right, and that's, Ms. McLean, do you need to call your clients now, go to position 6? And we go to cases that are assigned to Ms. Helen?
But we could go ahead with the ones that are handy to have, and I could do the phone call in a few minutes.
I just don't want to have a large lull in time while we're waiting for that to take place, but all right, we'll go ahead.
Your Honor, Mr. McLean has 1 through 18. I have 19 through 35 and the probation revocation position.
All right, so we'll take this position 8, but after that, can we go to positions that belong to Ms. Helen, please? Good morning, Mr. Cooper. Your case is 18 CR 004965H. You're charged with 2 counts of reckless conduct in that case, and the offense date was August 30th of 2017. Do you understand your rights today?
Yes, ma'am.
All right, whose case is this one? State and Sally, good morning.
Good
May I
morning.
have the state's recommendation, please?
Yes, Your Honor, the state's recommendation is 12 months to serve 86 days, credit for time served 43 days, the balance probated in FIB, and to comply with any defects orders.
All right, Mr. McLean, is that your understanding of the offer? I'm sorry, Ms. Zara, will you also give me very briefly factual basis supporting the state's offer at this time?
Yes, Your Honor. In this case, officers were dispatched to the incident location, which is a hotel at 450 Capitol Avenue in Atlanta. They were responding regarding a fight between the defendant and the mother of his children, Ms. Johnson. An employee saw that the defendant and Ms. Johnson, they only had one of their children with them. So the employee went up to their room that they were staying in and saw that there was their 5-month-old daughter crying in the bedroom alone. So she went and grabbed the child and went downstairs gave the child to the defendant and Ms. Johnson. There was another phone call to 911 after this one, and it stated that the defendant and Ms. Johnson had left the hotel and they left their children at the front desk. So a warrant was taken out for Ms. Johnson and the defendant. He was arrested.
All right, thank you. All right, Mr. McClinton, do you stipulate to batch basis, to get menu, and also with the understanding of the offer?
We do so stipulate, and that is our understanding of the offer.
All right, thank you. Mr. Cooper, I'm gonna ask you some questions to make sure you're voluntarily taking a plea today. Can you please raise your right hand? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury? Are you under the influence of any drugs or alcohol at this time? Are you satisfied with your attorney's representation in this case? Are you satisfied? You put your hand down. Are you satisfied with your attorney's representation? I need you to speak up, all right? Do you understand that by taking a plea today, you will have no further access to any court dates?
Yes.
And you understand by waiving this, you understand that by taking this plea today, you're waiving your right to any additional court dates where the state would have had to prove the charges against you beyond a reasonable doubt?
Yes.
And you understand the requirements that you're gonna have to take some classes, comply with any defects, orders, but you should not have any additional time to serve at the Fulton County Jail?
Yes.
All right, that's the charges of reckless conduct. Mr. Cooper, how do you plead?
Good.
I accept your guilty plea. Is there anything further from either the state or defense?
Nothing further.
Your
from
Honor,
the
I
state.
do need to confirm with them, Mr. Cooper, is that Rosegate Drive address the one I should put on the probation contact sheet?
Yes.
That was a yes, right?
Yeah.
And the 9830 is the phone number.
Yeah.
Okay, very good. Thank you.
All right, best of luck to you, sir. We have
Position 19, Peterson. Just talk loud. That's it.
All right, good morning, Mr. Peterson, your case 21 CR 00403AF. In that case, your charge was shoplifting with the offense date of April the 13th of 2020. Do you understand your rights today?
Yes, ma'am.
All right, the announcement that I have is that this case will be arraigned and we're gonna hold a bond hearing. Is that still correct, Ms. Helen?
Yes, Your Honor.
All right, and whose case is this for the state?
Mine, Judge.
All right, will you please put the offer to the record?
Yes, Judge, the state's offer for this is 12 months to serve, 14 days, credit for time served, 7 days, balance probated, stay away from the incident location, 844 Cleveland Avenue, East Point, Georgia, 30344, and completion of a theft prevention course.
All right. Oh, go ahead. Go ahead.
Yes, Judge, and the facts in this case is on April 13th, 2020, officers were dispatched to the Walmart on Cleveland Avenue in East Point, Georgia, in reference to a theft by shoplifting. Upon officers' arrival, they spoke with the loss prevention officer, who stated that he saw the defendant selecting and concealing clothing items and placing them in a bag. The defendant was stopped while attempting to exit the grocery side of the store without paying. The defendant was escorted to the loss prevention office. 19 unpaid concealed items were discovered, totaling up to $153.15. And Judge, the state, there is a current bond set for $1,000 surety bond, and the state would like to keep that the same due to him being a potential flight risk, and he runs a risk of reoffending. The defendant failed to appear for the plea and arraignment calendar, which was held on November the 4th, 2021. He has 3 probation violations, a total of 23 cycles, arrests for theft by receiving stolen property, another theft by shoplifting arrest. And as a result, the state would like to keep the bond the same.
Ms. Helen, you're not interested in the offer and your client is not interested in the offer that the state has presented at this time?
No, Judge, we're not.
All right, I'm gonna arraign Mr. Peterson's case. All right, Mr. Peterson, you've been formally charged with 1 count of theft by shoplifting, which has been formally accused by the Solicitor General of Fulton County. Ms. Helen, do you waive formal reading of the accusation?
I do, Judge.
I appreciate that waiver. At this time, the case will be reset for trial, and you will have the right to an attorney just as you had today. At trial, you will not have the burden to prove these charges against you. The state represented by the Solicitor General will bear that burden. If they do get a conviction, you can face a sentence of up to a year in prison or a fine of $1,000. Based upon this information, Mr. Peterson, how do you plead?
No, that's my mom.
I plead guilty.
You plead guilty? No, if we're arraigning your case today, you're pleading not guilty.
Or not guilty.
Ms. Helen has indicated that you don't wish to take the offer from the state. Is that correct?
Yes, ma'am.
I'm sorry, I need you to speak up. What'd you say?
Yes, ma'am.
You not wish to take the offer.
Maybe state the offer again, Your Honor. I'm sorry.
All right, Ms. Tole, will you please give us the offer again?
Yes, Judge, the state's offer is 12 months to serve, 14 days, credit for time served 7 days, balance probated, stay away from the incident location, 844 Cleveland Avenue, East Point, Georgia, 30344, and completion of a theft prevention course.
All right, and Ms. Helen, I'll ask you again, is your client interested in that offer? It sounds like he might be.
Mr. Peterson, when I came to the jail yesterday, you told me you wanted a bond hearing this morning. Is that still the case?
Yes, ma'am. I mean, due to the fact that I reside on Fort Valley now, so I just wanted to get it over with, get it over done with. So
you'd still like the bond hearing this morning, right?
yes, ma'am.
Okay, so we're gonna still go forward with it. Yes, Your Honor. He would not like to accept that offer, and we would like to have a bond hearing this morning.
All right, is there anyone from pretrial on the line? I believe I see Ms. Harrison. Good morning, Ms. Harrison. How are you today? Long time no see.
Good morning, Judge.
Can
I
I
have no additional history other than what was read.
All right, thank you for that confirmation. All right, Ms. Helen, please present your bond argument.
Yes, Judge. So for this theft by shoplifting, right now it does have a $1,000 surety. We are asking for a bond modification of a signature bond for Mr. Peterson. He's 41 years old. He's been in Georgia for the last 20 years. Yes, he's from Florida, but he's been here for the last 20 years. So I definitely think he's a resident of Georgia. He has 5 children currently that he is a primary parent caregiver of, 15-year-old, a 16-year-old, 7 and a 4-year-old. And so his father also lives in Jonesboro. So he has strong family ties here in Georgia. And he's also done construction work for the last 15 years, Judge. So he's employable. For this charge, Judge, we are asking for a bond modification of that signature bond. I don't believe he's a danger to the community. I don't believe he's a danger to anyone involved in this case, Judge. And so we are asking for that bond modification of a signature bond for Mr. Peterson. Again, he's not able to afford the $1,000 surety since it's been set. So we are asking for that $1,000 signature bond for Mr. Peterson.
How long has he been in Fulton County Jail?
16 days, Your Honor.
All right, give me one moment. I want to look up something. All right, at this time, I will modify Mr. Peterson's bond to a $2,000 signature bond for the jail. He is to absolutely stay away from that Walmart on Cleveland Avenue and East Point and have no alcohol, drugs, or weapons as a condition of that signature bond.
Understood, Judge.
Anything further from the attorney? Mr. Peterson, you are expected to keep your address current with Ms. Helen, the public defender's office, and with this court. I am giving you an opportunity here. If we hear that you're not reported to jail, you can right back where you are right now. Do you, report back to court? You went right back where you are right now. Do you understand that?
Yeah, I do, Your Honor. Yes, ma'am.
All right, best of luck to you. Who we have next?
Thank you, Judge.
33 Walton.
Thank you, Judge.
say 33, Walton?
I'm sorry, can you tell me that number again?
33 Walton.
All right. Good morning, Mr. Walton. Your case is 22 CR 002459A, in which you're charged with simple battery and obstruction in the state of May the 3rd of 2020. Do you understand your rights today?
Yeah.
All right, it's my understanding that this case as well will be a bond hearing and arraignment. Is that still correct, Ms. Helen?
Yes, Your Honor.
All right, at this time, I'm gonna arraign the case, but then I'll still let Ms. Foley put the offer onto the record. Mr. Walton, in the case 22 CR 002459A, you've been charged with simple battery and obstruction. Both have been formally accused by the Solicitor General of Fulton County, Georgia. Do you waive a formal reading of the accusation, Ms. Helen?
I do, Judge.
All right, thank you. At this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom the case is assigned. You have a right to an attorney, just as you've had today, and the state will have to prove these charges against you not prove these charges against you beyond a reasonable doubt in order to get a conviction. If they do so, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information I've presented you, Mr. Walton, how do you plead at this time?
Not guilty.
I accept your not guilty plea. Mr. Tully, if you would put the offer onto the record as well as the state's bond argument.
Yes, Judge, the state's offer at this time is for count one, simple battery, 12 months to serve, 28 days. Credit for time served, 14 days, balance probated, stay away from the incident location, 275 Pryor Street, Southwest Atlanta, Georgia, 30303, and no further contact with the victim, Jessica Rose. And for count two, obstruction of a law enforcement officer, 12 months to serve, 28 days. Credit for time served, 14 days, balance probated, and stay away from the incident location. And Judge, let me check what the current bond is set for.
Yeah, I wouldn't know. I don't know. Well, really,
He's also position 34.
Oh,
All right, thank you.
34.
Let me need that case number as well. Case 22 CR 00619A. Thank you for that. You're also charged with fear evasion and battery in a public transit station with the offense date of September the 24th. Ms. Helen, you also waived the reading for that.
And I do, Your Honor, and for case number ending in 2459A, I just wanted a verification of what his bond is. I don't believe that's holding him, Judge, and so I think we're gonna have an arraignment on that case. But the 6619A case, that bond is currently holding him, and I'd like to be heard on bond for that case, Judge, just to clarify.
All right, let's check. So you're saying that did he receive signature bonds for position 23?
That's what I have, Judge. I just wanted to make sure that's what the court had as well.
All right, let's investigate.
Wait.
Position 1 for 43.
That's position 30.
That's position
That's
34.
34.
Yes,
He does
ma'am.
have good bonds on that. What about 33?
Nothing for 33.
Oh, his signature bonds for those?
Nothing. He went straight to Pluto when he was the gold.
Oh, Ms. Helen, we're not seeing any bonds at all for position 33. He went straight. Are we able to, Mr. Tully, what do you see?
Yes, Judge, I'm checking right now. So,
Go ahead.
yeah, for position 33, I don't see a bond amount listed for that one. But for position 34, I do have the bond amount.
I have position 34. He's got a $3,000 good bond.
Mhm.
Position
So-
33 on Odyssey, Judge, under the booking number, I do see that it's a $1,000 signature. I don't know if that's being reflected anywhere else, but I do see that on the Odyssey jailing screen.
I'm checking. I don't think we see that at all. So I'm assuming we'll have to hold bond hearings on both. But let me arrange position 34. So clearly that case, I've arranged 33. Clearly position 34 is holding him. All right, Mr. Walton, I've read the charges in that case ending in 66198. You're charged with fair evasion and battery in a public transit station. Ms. Helen has waived the formal reading of the accusation.
I do, Judge.
At this trial, Mr. Walton, your case, at this time, your case is gonna be reset for trial. The trial will be scheduled by the state court judge. You have a right to an attorney, just as you've had today, and the state will bear the burden to prove those charges against you beyond a reasonable doubt. If they get that conviction and they're able to prove those charges against you, you can face a sentence of up to 1 year in prison or a fine of $1,000 based upon this information. How do you plead to the charges of fair evasion and battery in a public transit station, Mr. Walton?
Yield.
All right, thank you. I'll accept you like us to say. We're still seeing that he does not have, no one else is seeing the $1,000 signature line at this time. So I'm assuming we'll need the
There's
whole
no
line.
amount, small amount, should it be?
Are you-
I can screenshot it and send it, but I do see it showing on Odyssey.
Hold one moment.
Mm-hmm.
So, student said, so, when that issue is the officer,
All right, we are seeing it, so we'll hold the bond hearing.
Yeah.
Uh-huh.
Yes, Judge,
So
that's
what-
correct. Under the gelling screen in Odyssey, it
We got
says signature.
So we'll
bond.
go straight to position 34. Please proceed, Mrs. Hall.
Yes, Judge, this is bond hearing today for Mr.
Oh, wait, I said Mr. Coley.
Oh, I'm sorry, Judge.
Okay, yes,
One
Judge.
more, please. Okay.
Yes, Judge, for position 34, the state's offer for fair evasion, count one is 12 months to serve, 28 days, credit for time served, 14 days, balance probated, stay away from the incident location, 718 West Peachtree Street, Atlanta, Georgia, 30308. And for count two, battery in public transit vehicle or station, the state's offer is 12 months to serve, 28 days, credit for time served, 14 days, balance probated, and stay away from the incident location, 718 West Peachtree Street, Atlanta, Georgia, 30308. No further contact with the victim, Clement O'Day. And the last name is spelled O, D as in dog, E-H, and completion of an 8-week anger management course. And Judge, the facts in this current case, is on September the 24th of this year, the victim reported that he was assaulted on the northbound platform at the North Avenue Martis train station. He stated that a Black male wearing dark clothing and a female wearing all white beat him up, took his property, and threw it wayside onto the track. The victim suffered from a cut on his bottom lip and on his hand. On September 26th, which was 2 days after this incident, Detective Barden was assigned to the case. He was able to view the incident on the CCTV surveillance. The defendant and the other suspect could be seen exiting the train and walking toward the victim. After the physical attack, the victim can be seen stumbling and limping away towards the elevator. The defendant and the other suspect were also seen walking into an open handicap gate to gain access into the station without paying the required fare. Detective Barden was able to get a still shot picture and placed him on a be on the lookout notice that was sent to all MARTA police personnel. On September 29th, the defendant was detained by Georgia State University police due to him matching the description of the notice. And Judge, there is a current bond set for $3,000 in this case, $500 for the fair evasion, and $2,500 for the battery in a public transit vehicle or station, and the state would like to keep that the same. Judge, the state is concerned that this defendant, he runs the risk of reoffending, and he does serve as a danger to the community. Judge, he has a total of 46 cycles, which consists of convictions for several violent offenses. Judge, he also has an open case for criminal trespass and battery with the offense date of July the 20th, 2020. He committed this current offense while having the open case, which is on this calendar, position 33. Also the open case for criminal trespass and battery. He has a conviction for aggravated battery and aggravated assault with the disposition date of 2021. He has convictions for simple battery, willful obstruction of a law enforcement officer, and criminal trespass with a disposition date of 2019. And he has arrest for robbery and battery. As a result, Judge, the state would like to keep the $3,000 surety bond the same.
All right, thank you. Ms. Helen, please proceed.
Yes, Judge. Mr. Walton is 34 years old. He has one daughter who's currently 11 years old. He also is a primary caregiver of that daughter. He's from Muskogee County. However, he's been in Fulton County for the last 20 years, Judge. So I definitely think he's not a flight risk. On this date, September 24th, 2022, he actually had a job interview in Sandy Springs for food and hospitality service that he was headed to, Judge. So he is employable. He definitely did not make that job interview, unfortunately, Judge, but he has finished Job Corps in Montgomery, Alabama, as far as his highest education, Judge. And so, Judge, we're asking for a bond modification from the $3,000 to no more than $1,500. Mr. Walton is not able to afford the $3,000. He's the only person helping himself bond himself out. But again, he is a working father. He is employable. I do hear his history, Judge, but he was just released from the GDC. And he served his time, a year there, Judge. And so he understands the seriousness of this case, Judge. So we are asking for that bond modification currently for this fare evasion and battery, Judge.
Thank you. At this time, what I will do is I will convert the bond, the $500 debt bond on count one to a 500 signature, but the 2,500 on the battery and the public transit station will stand. So he will now have a $2,500 good bond and a $500 signature bond for the jail. Is there anything further from either party?
No, Your Honor. Did you hear that, Mr. Walton?
Nothing further, Judge.
Yeah, I heard.
Thank you, Mr. Walton.
All right, best of luck to you, sir. All right, who do we have next?
This is position number 13, conflict.
Is Ms. McLeod on the line? Ms. McLeod is not currently on the line. So I don't think we can go to that position.
Okay. Okay.
Is it, Ms. McLeod represents 13. Does she have a figure?
Position 35, Mr. Young.
All right, as Ms. McLeod is unable to attend court today, so we'll need to reset position 13 to the SAP calendar, I believe on Tuesday, if that's possible. Is that possible, Ms. Grace, or is that?
What's Tuesday's date?
Tuesday is the 18th.
Let's do it for the 20th, Judge.
All right, we'll have to reset, unfortunately, the whole week. So position 13 will be reset to the 20th.
Okay, thank you, Judge.
All right. All right, we're going to position 35. The announcement I have is that, oh, I don't have an announcement for that. I'm sorry, what did you say, position 35?
That's correct, Judge.
It's a negotiated plea, Your Honor.
Okay.
And I can re-email the announcements to you, Your Honor, if.
The announcement, okay, I see it, 35, next to 34. All right, Mr. Young, your case number is 22 CR 006631G, in which you're charged with fare evasion and criminal trespass with the offense date of September the 29th of 2022. Do you understand your rights today?
Yes.
All right, thank you. Is it Mr. Tully? Mr. Tully, please go ahead and put the state's offer onto the record, as well as very briefly the factual basis.
Okay, Judge. Yes, the state's offer, Judge, for count one, fare evasion is credit for time served 14 days, balance suspended, and stay away from the incident location, 2848 East Main Street in East Point, Georgia, 30344. For count two, Judge, is 14 days, balance suspended, and stay away from the incident location, 2848 East Main Street, East Point, Georgia, 30344, and that is to run concurrent with count one. And as far as the factual basis goes, all right, Judge. So in this case, on September the 29th of this year, the officers observed the defendant following behind a paying patron without paying the required fare. The officers approached the defendant with their badges displayed and identified themselves as the MARTA police officers. He was then aware of his violation. Upon checking the defendant's GCIC, they discovered that the defendant had an active MARTA suspension that began on September 25th of 2022, and it ended on October 25th, 2022. As a result of this offense, the defendant was issued an additional 90-day MARTA suspension with an effective date of October 25th, 2022, and it ends on January 23rd of 2023.
All right, thank you, Mrs. Tillman. Ms. Helen, was that your understanding of the offer? Do you stipulate a factual basis, ID, and venue?
We do, Judge, so stipulate, and we ask that the plea be accepted as negotiated.
All right, thank you, Mr. Young. I'm gonna ask you some questions. Make sure that this is a voluntary plea. Will you please raise your right hand? Do you swear in the affirmative testimony you give today for the limited purposes of taking the plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with Ms. Helen's representation?
Yes.
Did anyone force or coerce you into taking a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that you're giving up your right to any further court dates regarding this?
Yes.
All right, and you're giving up the right to have a state prove these charges against you beyond a reasonable doubt.
Yes.
And you understand that you cannot go back to the incident location here on Main Street?
Yes.
All right, as to the charges of fair evasion and criminal trespass, Mr. Young, how do you plead?
Yes.
I accept your guilty plea. Is there anything further from either party?
Nothing further from the state judge.
No, Judge.
All right, best of luck to you, Mr. Young. Your case is concluded. All right, who do we have next?
Position, the add-on, position number 1.
All right, are you Antonio Nora?
Yes.
Nora, your case is 22 CR 006392A. What's your charge of simple battery? You understand your rights?
Yes, and I had another case too.
Wait, well, don't tell me too much. Just do you understand your rights today?
Yes.
Okay, thank you. The announcement that I have is that this is a negotiated plea. Is that?
Yes, that's correct, Your Honor.
All right, thank you. Ms. Sally, will you please put the offer onto the record as well as very briefly the factual basis?
Yes, Your Honor. The state's offer in this case is a time served offer. The facts are that the defendant, this incident occurred at 400 Lucky Street in Atlanta. The defendant and the victim in this case, whose name is Talley, Talley, Lavelle, Lavelle, they were in a verbal altercation. And when the defendant went inside of his car and he pulled out a weapon, the defendant then pointed that weapon at the victim's face twice and put the weapon back inside of his vehicle. And there was a witness to observe this entire incident. Officers were on scene and they were not able to locate an actual weapon, but they did locate a holster and rounds of a magazine. Nothing further.
All right, thank you, Ms. Sauer. Ms. McLean, was that your understanding of the offer? And
Yes, Your Honor. The reason this case was put off for a couple of days was for everybody to make sure that in reading the police report, we understood that he did not have a remaining CP case. It was a bit confusing in Odyssey. And for a while, there was a CP case, which of course implies felony, that had something about the weapon in there. But now that we understand that as the case is transferred to state court, it remains, it has gone to the simple one charge.
And do you stipulate to the factual basis, ID, and venue?
We do.
All right. Mr. Norris gonna ask you some questions to make sure you are taking the voluntary plea as well. Will you please raise your right hand? Do you swear, Mr. Norris, can you hear me?
Ma'am,
Please raise your right hand.
yes,
Oh, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
yes,
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
no, ma'am,
Are you satisfied with your attorney's representation of you?
yes,
Did anyone force or coerce you into taking a plea today?
no,
Did anyone promise you anything in exchange for taking a plea?
no,
And do you understand that by taking the plea, you're not gonna have any further court dates regarding this charge?
yes,
And you're prepared to waive your right to have the state prove these charges against you beyond a reasonable doubt?
yes,
And you understand the requirements, essentially the time that you've served in Fulton County Jail will close your case?
yes,
As to the charge of simple battery, Mr. Nora, how do you plead?
yes.
I accept your guilty plea. Is there anything further from either party?
Nothing?
Your Honor, I just wanted to state for the record, I felt to make it known that the reason for the simple battery was because the defendant did strike the victim. So that was the reason for the battery.
Okay, I think. Say that again. Say it again. He's been in jail, what, 176 days? Is that correct? Ms. Derrick, you're muted.
I have 178.
So he served 178 days, credit for time served 178 days.
That's correct.
All right. I believe that will conclude Mr. Nora's case. Best of luck to you, sir, all right? I understand that there might be some other issues that you have with other cases or other concerns, but if you would go ahead and give Mr. McLean a call, he'll be able to help you figure that out, all right? Or,
I don't have a number.
Mr. McLean, will you give Mr. Nora a call at some point?
Yes, Your Honor.
He'll give you a call, all right?
All right,
Thank you. Have a good day. Who do we have next?
Position 6, Clark.
All right, I have this now negotiated plea. Mr. Clark, for case number 22 CR 0067138. What's your charge with sale of a martyr token and possession of marijuana less than an ounce with the offense date of June the 3rd of 2022? You understand your rights?
Yes, yeah, ma'am.
All right. Ms. Stark, you put the offer onto the record as well as very briefly the factual basis supporting it.
Yes, Your Honor. The state's offer in this case is 12 months to serve, 266 days. Credit for time served, 133 days. The balance probated, and an alcohol and drug evaluation and treatment if necessary. Your Honor, the facts of this case is that the defendant was seen by MARTA police going through the fare gate without paying the required fee. When approached, the defendant did not have a breeze card and he was arrested for these acts. And while being searched at the jail, there was marijuana and another substance found on his person. Nothing further.
All right. All right, Ms. McLean, was that your understanding of the offer? And do you stipulate to the factual basis, ID and venue?
It is, Your Honor, and we do so stipulate. I should mention, we have, because of the tradition of when we came into the misdemeanor court, we have a tradition of we do not represent people just before court. And if he wishes to go forward, I explained to him that he would be going forward pro se. And I believe that he does, I can say as a friend of the court, that he does have an understanding of what he's charged with.
Wait, Mr. McLean, are you indicating that you don't wish to represent him in taking this plea today? I'm
Right,
sorry.
I won't be signing off on it, but I think he can handle it pro se just fine based on my discussion with him.
And why is it that the public defender's office position, you had the opportunity to interview him? I'm not sure I understand your position here today.
Technically speaking, I really should be asking the court to give him freedom on a bond and come back next week when he's had more time to consider it, because I've just spoken to him. He was outsourced to Cobb County, and of course, they bring him back early on the morning of court. So it would be our preference to do it the other way. But it is a simple case. He does understand it, and I'm okay with what you're
But what
proposing.
I'm saying is, you've had the opportunity to interview him this morning, Mr. McLean.
I did.
And he understands that the position of the public defender's office is because you have not physically seen him, that you won't assist him with the plea. I'm just trying to clarify.
I think it's more the timing, Your Honor, that it's just right during court. I can get clarification if the court wishes, but
I'm just concerned because again, if your understanding is that you've had the opportunity to speak to him.
I did.
He qualifies, based upon our rules for your services, but now he has to go pro se. The court does have some concerns about why. I know in the past, they were saying that it was just not enough time to interview, but again, if it's that you'd like to speak to him again or something of that nature, or are you indicating to the court that he's operating outside of your legal advice and therefore you can't represent him?
No, I'm not implying that at all, Your Honor. I could talk to him again. In the meantime, I will talk to my office and get back to the court.
All right, let's do that, because if he has a right to the services of the public defender's office, I think that is the better way to go. And again, for you to sign off for him, but to take a pro se plea, I don't think that that's appropriate either.
Oh, no, I wouldn't be signing.
I don't
You're
think
correct.
so. So
You're right.
and again, he would need I believe if he wants the services of your office to understand the paperwork, he would be entitled to that, and I think that that's most appropriate. So let's let Mr. McLean again speak with Mr. Clark. We have these salaries offer already onto the record, so we won't have to go through that again.
Okay.
Okay. In the meantime, can we take another position?
So McLean, you'll be calling back?
Yes, I'm gonna talk to my office first and him second, and I may not even have to talk to him second.
Come on, Mr.
I'll
Snow.
put myself on mute and make that call.
Position 23, Mr. Snow.
All right, Mr. Snow, your case number is 22 CR 006616G, in which you're charged with theft by shoplifting and criminal trespass, each with the offense date of September the 29th. Do you understand your rights? You understand your rights, Mr. Snow?
Yes, ma'am.
All right, thank you. Mr. Tully, may I please have the state's offer? Let me confirm first that this is a negotiated plea? No, non-negotiated at jail. At issue is whether the case will be placed on probation. Is that correct?
That's correct, Your Honor.
My announcement list looks a little interesting this morning. All right, Mr. Tully, if you would please proceed, please put the offer onto the record. And also, if you give me very briefly the factual basis.
Oh, you're muted.
Mrs. Tully.
Oh, I apologize. Okay, Judge, for position 23, the state's offer for count 1, theft by shoplifting, is 12 months to serve, 30 days, credit for time served, 15 days, balance probated, completion of an anti-theft course, stay away from the incident location, 400 Edgewood Avenue, Atlanta, Georgia, 30312. And for count 2, criminal trespass, it's 12 months to serve, 30 days, credit for time served, 15 days, balance probated, and to stay away from the incident location of 400 Edgewood Avenue, Atlanta, Georgia, 30312. And that is to run concurrent with count 1.
All right. All right, Ms. Helen, please proceed.
So yes, Judge, this is a non-negotiated plea. We are asking for it to be balance suspended. So far, Mr. Snow has been incarcerated for the last several days. And so when I went down and spoke to him, we talked about how he could successfully get this case behind him, Judge. And so what we're asking for is for it to be time served, balance suspended. He's not able to afford the bond on either case. I think for this case, it's a $3,000 surety, and for the additional case, it's a $3,000 surety, Judge. He was currently homeless or residentially challenged at that time, Judge. While these thefts occurred, he's currently now living with a stable parent, which we are in a belief that there will not be any more theft by shopliftings now that he has a more stable situation in his life, Judge.
And Judge, the state would object to the balance, to the balance suspended. The state would like for it to be balanced probated, Judge, due to the facts of this case. So Judge, for position 24, that was an offense date of September 26th, where he went into the Exxon gas station and he stole several bottles of wine. He was criminally trespassed afterwards. 3 days later, Judge, which is position 23, he went into the same store despite being criminally trespassed, and he received adequate notice that he was not to return to the premises. He stole more bottles of wine. And Judge, I mean, he seriously has a high risk of reoffending. The state does believe he does need to take an anti-theft course, and we do believe that it should be balance probated and it should remain reported throughout the entire duration.
I'm inclined to agree with the state at this point. Ms. Helen, if I accept the state's recommendation and he's required to take the course, does your client still want to take the plea today?
Mr. Snow, they're requiring you, if you accept this plea today, to be on probation for that full year and do that theft course. You say it again, Mr. Snow?
Is it a way for me to, I'm sorry. All right,
Does he need to speak with you off the record, Ms. Helen? I don't want him to say something.
You sure can, Judge. I'll give him a call.
no, come on, let's run.
Mr. Snow, we can't hear you.
I don't want you to say something
I
about
can talk to her today, right now.
Yeah, I'll give him a call, Judge.
Let me talk to you right now.
All right, and if before you go, if there were some residential challenge issues, what I would ask is that we have a couple of different addresses, as well as we'd be allowed to send the notices to the public defender's office.
Understood, Judge.
All right, thank you. All right, while Mr. Snow is speaking with Ms. Helen, is Mr. McLean is still on the line as well. So I don't know that there's another position to take. Are there any private attorneys on the line? Or conflict attorneys?
Can we start at the competency?
No, we can't, because Mr. Howard or Mr. Walker, I don't see either of them. Oh, I see Mr. Walker, but I don't see Mr. Howard.
Okay.
I'm here, Your Honor.
Yeah, I saw you, Mr. Walker. Thank you for being here. But Mr. Howard isn't here yet, and I know that he's not expected for another hour.
Okay, and also Judge, just for that, for the competency, we are gonna need a Spanish interpreter for that.
Okay, I remember we reset it from last week, hoping to get one. I believe that there should be one, but I don't know. I'm hoping that that person will log on at 11. So we'll be in a very brief hold until.
Well, Ms. Helen is not on the phone with Mr. Snow yet, so.
Well, I'm calling, but no one's answering.
Yeah, because Mr. McLean is on the phone right now.
Oh, gotcha.
Okay, so let's take another, Ms. Helen, can you handle another?
Sure can. Yeah, sure.
Position 25, Mr. Standifer.
All right, Mr. Standifer, your case number is 22 CR 006630G, in which you're charged with loitering and prowling with the offense date of September the 30th. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Tully, let me see, the announcement I have is that this is in fact negotiated fee. Is that correct?
That's correct, Judge.
All right, Mr. Tully, if I can have the offer as well as very briefly again, factual basis.
Yes, Judge, the state's offer is credit for time served, 13 days, balance suspended, stay away from the incident location, 1068 Robert Smalls Way in Atlanta, Georgia, 30318. And Judge, factual basis in this case is on September the 30th of this year, Officer Ware was dispatched to the incident location. When officers arrived, the caller advised the officer that he observed the defendant entering into vehicles and walking into unoccupied apartments that were under construction. The caller was able to describe the defendant's complexion and what he had on. While the officer was on scene, he located the defendant inside apartment 1073. The defendant told the officer that he was homeless and he did not reside at the location. He also told the officer that he was able to get in through the back door. The defendant was then placed in custody and transported to Fulton County Jail.
All right, thank you. Ms. Helen, was that your understanding of the offer, and do you stipulate factual basis, ID, and venue in this case?
We do stipulate, Judge, and we ask this court to accept the plea as negotiated.
All right, thank you. Mr. Standifer, I'm gonna ask you some questions at this time, and then we can take your plea, okay? Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
No.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time? Are you under the influence of any drugs or alcohol?
No, ma'am.
All right, are you satisfied with Ms. Helen's representation?
Yes, ma'am.
Did anyone force or coerce you into taking a plea today?
We'll say that one more time, please.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And do you understand that you're not gonna have any more court dates or any chance to present any evidence you may have had in your favor to result in dismissal of the charge?
Yes, ma'am.
And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And even though the time at Fulton County Jail should close out your case, you understand you cannot go back to that incident location on Rocket Small Way?
Yes, ma'am.
All right, as to the charge of loitering and prowling, then for how do you plead?
Yes, ma'am.
What do you
I'm
plead?
sorry, how do you plead?
I plead guilty.
All right, I accept your guilty plea. Is there anything further from either the state or the defense?
Nothing further, Judge.
No, Judge.
All right, best of luck to you, Mr. Stanford. I believe that will close your case.
Thank you.
Oh, Your Honor,
On the competency calendar, which position required an interpreter?
It's gonna be position number 2, Mr. Ayala Gonzalez.
We may have to reset it. We're working on that now. I'll make the announcement if we do.
Okay.
And I spoke to Mr. Howard earlier today, Your Honor. I believe position number 2 was gonna be a reset anyway, so I don't think it would be detrimental. But I can let Mr. Howard confirm that.
All right, thank you, Ms. Walker. All right, Mr. McLean, you were sounding?
yes, Your Honor, would you like me to put in chat or simply orally announce that Mr. Clark is now ready to go forward and I will represent him? I've
All
said
right, we'll do Mr. Clark's case while Ms. Helen speaks with her client, Mr. Snow.
Okay.
So Mr. Clark will be brought back once again. All right, and the announcement, Mr. McLean?
That's a negotiated plea. I will represent him. I've satisfied the concerns that I had. And I feel that this is definitely in his best interest. He understands the procedure. He understands the allegations. He understands his choices. And he is pleading guilty.
All right, thank you. All right, Ms. Sowery's already given us the offer and she's put the factual basis onto the record. Mr. McLean, do you stipulate to the factual basis, ID and venue?
We do.
All right, I'm gonna ask you some questions. Mr. Clark, can you please raise your right hand?
Yeah, ma'am.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah, ma'am.
All right, thank you. Put your hands down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coercion to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for a plea?
No, ma'am.
And you understand that this will be the end of the case? You will not have any further court dates where the state would have to prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you understand that as part of this, you will have to undergo an alcohol and drug evaluation and treatment? But otherwise, you should not have additional time to serve at the Fulton County Jail.
Yeah, ma'am.
As to the charge of sale of a marked token and possession of marijuana less than an ounce, Mr. Clark, are you pleading?
Yes.
I accept your guilty plea. Is there anything further from either party?
Nothing further
Nothing.
from the state.
Nothing, Your Honor.
All right, best of luck to you, Mr. Clark. That concludes your case.
Hey, Mr. McLean, can you go ahead and ask for the breakout session for Mr. Berry, position number 3?
I could do a breakout session, or I can call a number or be called.
I don't have a number for you to call, on the announcement, it said breakout session.
Breakout session's fine.
Mr. Jordan, we put them in the breakout, please.
And Judge, we're ready on position 23 and 24.
All right, Ms. Helen, your announcement.
Judge, it's going to be a non-negotiated plea. The only thing that's non-negotiated is that I'd like to petition the court to see if Mr. Snow can use his NOLO for at least position 23.
And he no longer objects to the probation in the class.
He does not, Judge, but I am requesting to see if this court, as well as the state, will allow him to use his NOLO in position 23.
All right, Ms. Harrison, can I have Mr. Snow's history, please, position 23 and 24?
One moment, Judge.
Thank you.
$16 cycles. Last arrest was, one moment. Last arrest was March of this year for 3 counts of criminal damage to property. Second degree. Case number is 22 CP 207564. That charge was dismissed. Record indicates an open case pending in DeKalb County for criminal trespass, case number 19C28511. Also indicates an open probation in Fulton County for theft by shoplifting, 21 CR 002590B like boy. Sentenced November of 2021, 12 months probation, 30 days jail. Criminal trespass and theft by shoplifting, willful obstruction of law enforcement officers, 21 CR 006378G. Sentenced November of 2021 with 12 months probation, 30 days jail.
Thank you, Ms. Harrison. Is there any indication whether he's used his NOLO in the last 5 years?
No.
Yeah.
He is not.
I'm checking now.
I'm sorry, I'm losing my voice because I have a cold, but I would like to remind the court that using a NOLO once in every 5 years is a DDS guideline. There's not any statutory authority as far as a criminal offense, Your Honor. And so it sounds like he's already on probation for 2 shoplifting courses or 2 shoplifting cases, and this is his 3rd in the last 12 months. So we obviously would be objecting to a NOLO.
I'm sure, I knew that would be the state's position, Mr. Walker, but the courts, my own personal is, have you used it in the last 5 years? I do understand that that's TDS, and it's up to me to decide whether he can use it.
I understand, but just because he's already pled guilty to 2 shoplifting cases in the last 12 months, there is some concern there.
I understand. Thank you, Mr. Walker. I just want to confirm.
I am not showing it used, Judge.
All right, and Mr. Tully, I know that Mr. Walker has spoken, but is there anything you'd like to add?
That's correct, Judge. He's spoken. I'll second to that. The state would object.
All right, I would, if Mr. Snow takes the plea today, he would be required to plead guilty to position 23, but I would allow him to use the NOLO plea for position 24. Does he wish to take the plea today?
Yes, Your Honor, and thank you, Your
This
Honor.
meeting is being recorded.
Sorry, there's someone sounding?
Recording for the YouTube, Judge.
Oh, okay. I'm sorry. Thank you, Ms. Bree. That was confusing for a moment. All right. What we're gonna do is we'll go ahead and ask Mr. Snow some questions. Mr. Snow, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
I'm gonna ask you some questions twice, and to the first that you're gonna reply that you plead guilty, you put your hand down. And to the second set, you're gonna tell me that you plead NOLO, all right? All right. Mr. Snow, are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with Ms. Helen's representation?
Yes.
Did anyone promise you anything in exchange for taking a plea today?
No.
Did anyone force you to take a plea today?
No.
And you understand that, as part of taking the plea, you are going to have to complete the anti-theft course and stay away from that location on Edgewood?
Oh, yes.
And you understand you're not gonna have any other court dates regarding these charges, correct?
Yes.
All right, as to the case ending in 6616, in which we've discussed and pleaded guilty, Mr. Snow, how do you plead?
Oh, guilty.
All right, and as to the case ending in 6617G, in which you're charged with theft by shoplifting as well, Mr. Snow, how do you plead?
Guilt. What was it? No contest?
Yes. All right, I accept your pleas at this time. Is there anything further? And again, Mr. Snow is gonna be required to also list the public defender's office on his probation intake form as an address where notices can be sent, so that we don't lose track of him. All right?
Understood, Judge. Thank you, Judge.
That's concurrent. All right, best of luck to you, Mrs. Snow. We have next.
Position 29, Mr. Tucker.
All right, good morning, Mr. Tucker. Your case is 22 CR 006714E, in which you're charged with loitering and prowling with the offense date of September the 29th. You understand your rights?
Yes, Your Honor.
Did you hear your rights? You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. This proceeding is being broadcast over the internet as a live stream. It is also being recorded. Do you understand those rights today here, sir?
Yes, Your Honor.
All right, thank you. The announcement I have is that this is a negotiated plea. Is that correct, Ms. Helen?
Yes, Your Honor, it is.
All right, Mr. Tully, if I could have the offer as well as, again, briefly, the factual basis of this case, I appreciate that.
Yes, Judge. The state's offer in this case is 12 months to serve, 28 days, credit for time served, 14 days, balance suspended. Stay away from the incident location, 350 Peachtree Hills Avenue Northeast, Atlanta, Georgia, 30305. And Judge, as far as the factual basis, briefly, on September 30th, 2022, the defendant was seen late in the evening around 10 o'clock p.m. pulling on multiple doors in the parking lot of a residential property in which he does not live or have any associates.
All right, understood. Ms. Helen, is that your understanding of the offer? And do you stipulate the factual basis? I do obey you.
We do so stipulate, Judge, and we ask the court to accept the plea as negotiated.
All right, thank you. Mr. Tucker, I'm gonna ask you some questions as you've seen me do. Please raise your right hand. Do you swear in front of the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, thank you. Put your hands down. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Are you satisfied with Ms. Helen's representation?
Yes.
Did anyone force or coerce you into taking a plea today?
No.
Did anyone promise you anything in exchange?
No.
And you're prepared to waive your right to a court date and to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand the requirements that you, the time you serve should essentially close your case, but you cannot go back to that apartment complex on Peachtree Hills Avenue?
Yes, Your Honor.
All right, after the charge of loitering and prowling, Mr. Tucker, how do you plead?
Guilty.
I accept your guilty plea, and that will conclude his case unless there's anything further from either Ms. Helen or Ms. Fuller.
No, Judge.
All right, best of luck to you, Mr. Tucker. All right, who do we have next?
Excuse me, we're still waiting on the breakout session for 4 South.
Oh, Mr. Jordan, he may be busy. Mr. Jordan, will you put Mr. McLean in a breakout for some? Melissa, will you ask me? Oh, it's Ms. Champion. Ms. Champion, will you put them in the breakout? All right, who do we have next?
Position 30, Vickers.
All right, good morning, Mr. Vickers. Your case number is 22 CR 006618G, in which you're charged with simple battery, family violence, and criminal trespass and damage to property. Do you understand your rights today?
Yes, ma'am, I do.
It's my understanding that this is a bond hearing.
That's correct, Judge.
All right. And I need to arrange this case. Opposition 30.
Thank you.
All right. Mr. Vickers, you've been formally charged with simple battery, family violence, with criminal trespass and damage to property, which have both been formally accused by the Solicitor General of Fulton County. Ms. Helen, do you waive the formal reading of the accusation?
I do, Judge.
I appreciate that waiver. At this time, the case will be set for trial and scheduled by the state court judge to whom the case is actually assigned. At that trial, you will have a right to an attorney, Mr. Vickers, just as you had today. And you do not have the burden to prove the charge against you. The state bears that burden. And if they do meet their burden and get a conviction, you face a sentence of up to 1 year in prison or a fine of $1,000 for each charge. Based upon this information, how do you plead, Mr. Vickers?
Not guilty.
I accept your not guilty plea. Mr. Tully, we'll go to you. We'll go straight to the bond hearing. Will you please give me the state's position regarding the bond?
Yes, Judge. So there's a current bond of $7,500 set in $6,000 for a simple battery, family violence, and for count 2 criminal trespass, damage to property, $1,500. And the state would like to keep that the same. Judge, in this case, on September 27, 2022, officers were dispatched to the incident location in reference to a domestic dispute. The victim stated that the defendant started a verbal argument over infidelity and helping her out around the house. The altercation escalated, and that's when the defendant slapped her in the back of the neck. The victim stepped outside to call the police, and when she got back in the house, she noticed that the defendant had damaged her laptop. Judge, the state is very much so concerned about this defendant. He does have a high risk of reoffending, and he is a danger to the community. Judge, he currently has a conviction for aggravated assault, criminal damage to property in the 1st degree, battery, family violence, and possession of a firearm during the commission of a felony against the same victim in this case. And that victim, is Tykera Smith in this case. Judge, he also has an open battery, family violence case against the same victim. Judge, also, he has an open aggravated assault case, possession of a firearm or knife during the commission of or attempt to commit certain felonies, cruelty to children in the 3rd degree, and battery, substantial physical harm. And that also involves the same victim in this case. And as a result, the state would definitely like to keep the bond amount the same, totaling to $7,500.
All right, thank you, Ms. Helen.
Yes, Judge. So today we're having a bond hearing for Mr. Vickers. Currently, he's 29 years old. He is a college, has some college experience, 2 years at Georgia State for business management. Currently, as his own full-time occupation, he's an entrepreneur of TNJ Services, his own business for the last 5 years. He does share a 5-month-old son with Miss Smith currently. And so he is, from my understanding and my perspective, speaking with Mr. Vickers, he is the primary financial caregiver of this family. And so also that the alleged accuser in this case is not currently working. So he is the primary financial breadwinner in this family, Judge. And so I do hear the history. I do hear the cases, Judge. So we're asking today for a bond modification from the simple battery of the $6,000 to a $1,000, the criminal trespass and damage to property to a $500, Judge. And we'll go through the Ayala factors, Judge. He is a lifetime resident of Fulton County. I don't believe he's a flight risk. Currently with the other cases, they have a no contact with Ms. Smith. And I've spoken to Mr. Vickers about that. So he understands that currently with those other cases, as they're still ongoing, there's a no contact with Ms. Smith, even though that they share that 5-month-old, Judge. we are asking for that bond modification, again, because we don't believe he's a danger to the community. These allegations are not to random people of society. Unfortunately, these allegations are with the alleged accuser, and they're still open, Judge. So I don't believe he's a danger to the community. And like I said, I've spoken to Mr. Vickers. The other cases have a no contact order, so he has no contact with Ms. Smith. But Judge, we are asking for that bond modification to the $1,500 from the $7,500 surety bond.
All right.
Yes, Judge, the state would definitely object to that due to the fact that, due to the history of the parties, due to.
I got you, Mr. Tully. Thank you. One question that I did have, he's been in jail how many days?
I have 15 so far for this current case, Judge.
Sure.
And I also think that Ms. Smith is on the line, Takira Smith. Just wanted to mention that.
Okay, I'll sound for Ms. Smith at this time. And my question will be, is if, are you asking reset to, I know I've arraigned this case, Ms. Helen. Are the state and defense close to reaching some type of agreement to resolve this case such that we could reset to another SAP calendar? Are we resetting further notice to a division judge at this time? I'm just assuming, I'm asking this question based upon me not modifying fire. I'm just trying to understand where we might be. And I'm not saying that I'm not gonna modify it. That's my question. The offer that's on the record, your client is not interested in taking at this.
He is not, Judge, and he really wants to take this case to a full jury trial.
Okay, understood. I'm sounding for Ms. Smith at this time.
Yes, ma'am.
Ms. Smith, do you wish to make a statement? If you do, you need to turn on your camera.
Hold on 1 second.
You're not required to make a statement.
Okay, then I don't want to make one.
All right, thank you. All right, at this time, bond will remain as set and the case will be reset for a jury trial. All right,
Judge.
Is there anything further from either party?
No, Judge.
Nothing further, Judge.
All right, best of luck to you, sir. Who do we have next?
Your Honor, I'm sorry to interrupt. For position 11, I noticed that he's on the call. He was released, so we do not have an offer at this moment. I just wanted to bring that to the court's attention to possibly go ahead and dismiss him.
Okay, Mr. Efron, if you're on this call, you're not required to be here today. What you do need to do is keep your address current with the court. And if you are represented by the public defender's office, make sure that they have your correct address as well. All right?
All right, thank you.
All right, thank you, Ms. Sowry, for that. Take care.
Yes, Your Honor.
Thank you, you too.
All right. All right, who do we have next?
Position 20 and 21. Mr. Pitts.
All right, thank you. Good morning, Mr. Pitts.
Good morning.
You have two cases. In your first case, 18 CR 005802H, you're charged with one count of suspended or revoked license, driving without a valid license, failure to have your license on person, and a tag light. And your second case, 22 FPA, that's interesting, 00004, you're charged with failure to appear for a fingerprintable charge. All right, the announcement that I have for those.
We have the.
We're not passing position 21.
Yes, Judge, that's correct. I emailed Miss Grace last night a null pros for position 20.
And I find it, so that one is not before me today at this time. That's dismissed. We'll only be dealing with the suspended license and related charges for the case ending in 58028. And my understanding is this is a negotiated plea.
Yes, Judge.
All right, Mr. Tully, if you would put that onto the record.
Yes, Judge, the state's offer, this is for position 21, correct?
Position 20. 21 was the no cross, correct?
No.
No, Judge.
Oh, it's the reverse.
It's reverse, correct. Position 20 is a null pros, and then for position 21, credit for time served, 8 days, balance suspended.
Understood.
Okay. All right, Ms. Helen, do you stipulate to factual basis, ID, and venue?
I do.
All right, Mr. Pitts, I'm gonna ask you some questions to make sure you're taking the plea voluntarily, okay? Will you please raise your right hand? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge? And under the penalty of perjury? And do you understand, you can put your hands down, do you understand your rights here today? You have a right to remain silent. And other than answering my very limited questions for the purpose of taking the plea, and you also have a right to an attorney. This proceeding is being broadcast over the internet. That means anyone can watch it. Do you understand that?
Yes, ma'am, I do.
All right, thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am, I'm not.
Are you satisfied with Helen's representation?
Very.
All right, great. Are you under the influence, I'm sorry, did anyone force or coerce you to taking the plea?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
And you understand you're not gonna have any further court dates regarding this charge?
Yes, ma'am, I do.
And you're prepared to waive your court date?
Yes.
All right, you understand at the time you served in the Fulton County Jail, should close your case?
Yes.
As the charges previously listed, Mr. Pitts, how do you plead?
Yes, Your Honor.
All right, I accept your guilty plea. Is there anything further, Mr. Tully, Ms. Helen?
No, Judge.
Grace, if you have a question? No? Oh, okay, hold on. That will conclude Mr. Pitts' case, I believe. Hold one moment.
Thank you, Judge.
Okay, I'm receiving information that we cannot take pleas on an FTA. And that what should have happened is we should have received the null price for, I'm sorry, say it again. Can I speak to Mr. Walker in a breakout very quickly? And Ms. Helen can listen, Ms. Helen can come as well.
Understood, Judge.
Come to us.
Mr. Walker, do you mind? Mr. Tully, you're welcome to come as well. It's a procedural issue here.
Can I be included as well, Judge?
If you would like, yes, ma'am.
Two of them.
Mr. Pitts, what's actually gonna happen is we're gonna dismiss both of these cases against you, so that's the end of this for you. All right?
Yes, ma'am. Thank you.
Thank you.
Take care, have a good day. And we'll figure out the paperwork at some point shortly hereafter. Who do we have next?
17 more, and also Helen, when your client Thickman wants to talk to you on the phone, if you can give a call.
Gotcha. I'll call.
All right, good morning, Mr. Moore. Your case number is 21 CR 00990 F, in which you're charged with battery, substantial physical harm, and battery friendly violence. Each would be offense date, November the 16th of 2020. You understand, right?
Yes, ma'am.
All right. Let's see, the announcement that I have is that if this is Mr. McLean's case. Is Mr. McLean here?
Funny word.
17 right there, that's fine.
It is Mr. McLean.
I can give him a call, Judge.
He's still in the breakout room, Judge.
Oh, wow.
Okay.
Okay,
Okay, can't do that. Okay.
have a seat back. Go ahead and have a seat. Can't do your case right now.
We can do,
Position 27, Tolan.
All right, the announcement I have is that this will be a bond hearing, and I'm gonna arrange this case. All right, Mr. Tolan, your case is 18 CR 003670Y, in which you're charged with simple battery and one count that I will not sound at this time, with the offense dates of July the 9th of 2017. Ms. Helen, do you waive a formal reading of the accusation?
I do, Judge.
At this time, the case will be reset for trial and scheduled by the state court judge to whom the case is assigned. At this trial, Mr. Tolan, you will have the right to an attorney, just as you've had today, and you do not have the burden to prove the charges against you. The state, represented by the Solicitor General, bears that burden and will have to meet that burden by proving the charges beyond a reasonable doubt. If they get a conviction, you can face a sentence of up to a year in prison or a fine of $1,000 that can run concurrently or consecutively for each charge. Based upon this information, how do you plead?
Not guilty.
I accept your not guilty plea. Let's proceed with bond arguments. Is a breakout required due to the nature of the charges?
No, Judge, I just wanted a verification if this bond was actually holding Mr. Tolan. I had a $2,000 cash bond, but I don't have that it's actually still holding him. So I wanted to see if it was or was not.
Do you believe he's made it?
I
He
believe
has
so,
2
Judge.
open felony cases.
So then that would just be an arraignment, Your Honor, then.
Okay. Well, we've arraigned it, so there's nothing further, Ms. Helen?
Understood, Judge.
All right, Mr. Tolan, Ms. Helen has informed me that there's nothing further to address today. So just stay in contact with your attorney, all right? All right, best of luck to you, sir. All right, who do we have next?
position 14, Mr. Lewis.
All right, good morning, Mr. Lawrence. Your case is 15 CR 003322. There's a letter missing, maybe. In which you're charged with obscured or missing license plate, driving without a valid license, and expired license plate, each with the offense date of March 29th of 2013. Do you understand your rights today?
Yes.
All right, it's my understanding that this is a negotiated plea. Is that correct? This is Mr. McLean's case, isn't it?
Yes.
We can't take this case right now.
Okay.
Mr. McLean is in breakout.
All right.
So just please hold. All right, is there another, is Ms. Helen concluded?
I don't think so. I still have 26, 28.
Okay, could we do another position that belongs to Ms. Helen?
The only position I have here is 26.
Can we do that position?
All of my, the other cases that I have is for Mr. McLean.
Could we do 26?
And Judge, I believe Mr. Thicklin notified the jailers he wanted to talk to me. That is the next case. Can I just call him real quick before we call?
Yes. Yes,
And I
please.
don't have anything for 28, and that is her case as well.
He's
I
calling
knew
you.
about position, for the competency position 11. Is Mr. Howard?
Mr. Howard's not here. We can't start competency yet.
26, they're starting with.
And Judge, we're ready on Mr. Thicklin.
All right, thank you. The announcement is that it's gonna be a bond hearing and an arraignment.
That's correct, Judge.
All right, Mr. Demario Thicklin, your case 22 CR 00321 J, in which you're charged with battery family violence, has been formally accused by the Solicitor General of Fulton County. Ms. Helen, do you waive the formal reading of the accusation?
I do, Judge.
Thank you. At this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom the case is actually assigned. You do not have the burden to prove these charges against you. The state represented by the Solicitor General will bear that burden, and they will have to prove that burden beyond a reasonable doubt to get a conviction. If they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Thicklin, how do you plead?
Not guilty.
I accept your not guilty plea at this time. Ms. Helen, you are asking for a bond hearing?
I am asking for a bond hearing, Judge.
All right, Mr. Tully, please proceed.
Yes, Judge, the current bond set for this case right here is a $20,000 surety bond. And as a result, the state would like to keep that the same. Judge, in this case, on September 13th, 2020, officers were dispatched to the incident location in response to a domestic dispute. When officers arrived, the victim told officers that her and the defendant were arguing about the sink being stopped up. The victim stated that the defendant then punched her in the face, causing the entire left side of her face to swell. Judge, the state is concerned that the defendant is a flight risk, and he does run the risk of reoffending. He currently has an open case, Judge, for possession of controlled substance in Schedule 1 or 2 with intent to distribute, and possession of firearm by a convicted felon. And that was with the offense date of October 4th of 2022. He got rearrested for the case I just mentioned while still out on bond for this current case. He has 2 probation violations as well, which shows his complete disregard for the law. He also has burglary, arrest for burglary, robbery, and theft by deception. And as a result, Judge, the state would like to keep the bond the same, which is a $20,000 surety bond.
All right, thank you, Ms. Harrison. Do you have anything to add to that history?
No, Judge.
All right, thank you. Ms. Helen?
Yes, Judge, this is a bond hearing for Mr. Thicklin. He's 27 years old. He currently is a lifetime resident of Fulton County. He was born at Grady Hospital. He has strong family ties in Fulton County. His mom's in Fulton County. Prior to getting arrested to this, he was working full-time packaging with Duracell, Judge.
This meeting is being recorded.
Before that, Judge, he was working at Food, Hospitality and Services for the last 4 to 5 years, Judge. So he is employable. I do hear his history, Judge, but I didn't hear any convictions. I hear that those cases are open. Judge, we are asking for a bond modification from the 20,000 for this battery family violence down to no more than a $1,500 bond. Judge, for the same charges through this court, we've seen much less bonds assigned to this charge. And so, Judge, based off of those factors, we are asking for a bond modification of that amount. And also for the bond factors, he has had no contact with Ms. Harmon and has stayed away from that location, Judge. So we are asking for that bond modification from the 20,000.
All right, one moment, Ms. Helen.
Yes, ma'am.
All right, at this time, I will modify the bond down to the original bond amount because I'm receiving information that it in fact doubled because he was picked up for forfeiture. The bond will be a $10,000 surety bond, and he is to have no contact with the alleged victim and stay away from that incident location, have no alcohol, drugs, or weapons as a condition.
Understood, Judge. Mr. Thicklin, did you understand that?
Yes, ma'am.
Okay, thank you, Mr. Thicklin. Thank you, Judge.
All right, best of luck to you. Who do we have next? Oh, Mr. McLean is back, so we're able to take some of his positions.
Your Honor, I could make an announcement and a request on Mr. Marion Berry.
Okay, please proceed, position 5.
I'm sorry.
Go ahead, Mr. McLean.
Mr. Berry has told me something I need to have an investigator get documents on. I think I can do that within a couple of business days, which would be Friday and Monday. It makes no difference to us whether it would be a reset request to this coming Tuesday SAP or 1 week, 7 days to a week from today. I think we'll have the document we need by then in order to proceed.
All right, so we'll reset him to the SAP calendar on 10/20.
Okay.
All right, Mr. Berry, did you hear that? Your case will be reset to next week, so there's nothing further for us to do today. All right, see you next week. Best of luck to you, sir. All right, who do we have next?
Position 14.
All right, I think I asked Mr. I think I've already explained the rights to Mr. Lewis and his case. Mr. McLean, we're on position 14. The case of Jamel Lewis, he's already heard his rights to the 2013 case. And it's my understanding that this is a negotiated plea. Is it still a negotiated plea?
On the case that is on the calendar with the 14 position, yes, the case that's annotated or notated within the offer, he is asking to wait a week on that. He is considering that. But the case.
All right, so you're asking for a reset of this case for 1 week?
The case that is not the actual position, but is mentioned inside that offer. Let me turn to my paperwork.
And I'm sorry.
My question is, Mr. McLean, does he intend to take a plea today? Or are you asking more time for him to consider the global offer?
The global offer would be fine because it's going to hang him up that much anyway.
Okay, so no plea today?
And let's do that next week.
All right, and Ms. Sauer was a statement of no objections?
I was just gonna state that it is a global offer, so he the offer goes to both cases, not just the 2013 case.
All right,
But
so
the
we'll
state is
reset.
making that make sense, so I understand. Right.
We'll reset this case 1 week. Mr. Lewis, your case will be reset. Mr. McLean will likely speak with you before then, and it's our hopes that we'll be able to resolve your case at that time, all right? So we will see you in 1 week.
All right, thank you.
All right, take care, Mr. Lewis. All right, who do we have next?
Position 9, Mr. Curtis.
That, of course, is a negotiated plea, Your Honor. There's no probation involved.
All right, Mr. Curtis, your case is 22 CR 006175E, in which you're charged with theft by receiving stolen property with the offense date of April 6th. You understand? Oh, you have an absolute right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. And this proceeding is being recorded. And I apologize, I did not look over. Do you understand your rights?
Yes, ma'am.
All right. Let's see, Ms. Sauer, will you please put the offer onto the record? As well?
Yes.
Right, hold on, sis.
Yes, Your Honor, the state's offer in this case is 12 months to serve, 365 days, credit for time served, 191 days. And with him getting the 2-for-1 credit, there is no balance. We are also adding a stay away from 640 interchange that's in Atlanta, and no contact with the victim, whose name is Mark Hogan. That's HULGIN. Your Honor, briefly, the facts are that the defendant was in possession of a company car that belonged to the victim's company, and he was in possession of that vehicle without permission. The defendant should have known that the car was in fact stolen. Nothing further.
All right, Mr. McLean, was that your understanding of the offer? And do you stipulate to factual basis ID and venue?
Yes, Your Honor, it is our understanding of the offer, and we do so stipulate.
All right, Mr. Curtis, I'm gonna ask you some questions. Please raise your right hand. Do you swear in front of the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation? Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that you're not gonna have any further court dates about this case, or you might have been able to present some evidence in your favor?
Yes, ma'am.
As to the charge of theft by receiving, how do you plead?
Guilty.
I accept your guilty plea. The time that you served at Fulton County Jail should close out your case, but you must stay away from that location and have no contact with that victim, all right?
And can I get the name? Mark what?
I'm sorry, Ms. Sauer, can you give us the
The state.
victim's name one time so we can put it on the orders?
Yes, Your Honor, it's Mark, last name Hogan, HULGIN, and the stay away is 640 interchange in Atlanta.
All right, is there anything further from either party?
No, Your Honor.
Nothing
All
further.
right,
from the state.
that concludes this case. Best of luck to you.
Thank
All
you.
right, who do we have next?
Position 17, Michael Moore.
All right, I believe I've already read the charges in this case. You understand your right?
Yes, ma'am.
All right, Mr. McLean, the announcement I have is that this case is gonna be arraigned.
Yes, Your Honor, we can waive the formal reading. He does ask the court for a signature bond. He did not intend to miss court. And he said, we should look at the address that it went to. I did look in the computer.
Okay, before you do that, Ms. McLean, does this case, you said you'll waive the formal reading. Are you still asking it to be arraigned today? Or are you gonna submit a waiver of arraignment?
Within tomorrow, by tomorrow, I can fill out a form and submit it.
That's fine. And you're asking to be heard on bond?
Yes.
All right, thank you. Ms. Sauer, please proceed with the state's position regarding his bond.
Your Honor, we are objecting to any revision of his bond. If we can hear from pretrial regarding his GCI, please.
What's the current bond? Do you know what the current bond is?
I'm looking it up right now, sorry.
All right, well,
It's a 10,000 surety bond on the battery substantial harm and 1,000 cash on the battery family violence.
all right, so I'm assuming it doubled because he forfeited this bond as well, is that correct? Does anyone know? We'll go to Ms. Harrison. Ms. Harrison, can I have the history? Ms. Grace, can you tell me if that's what's happening?
Judge, I don't have a history on this defendant.
Okay.
I have the history, Your Honor. I can put it on the record. This defendant has his history of violence goes back to at least 2003, Your Honor, with a simple battery. That was a guilty conviction, ag stalking, 2011 ag assault, 2013 ag assault and false imprisonment. That was with a different victim, a 2018 battery and ag strangulation that resulted in a guilty conviction, and that was this very same victim. There's also a 2020 false imprisonment notated with no disposition. Your Honor, in this case, officers were dispatched to the Atlanta Medical Center in reference to a person injured from a domestic dispute. That victim is Tonika Franklin, that's Tonika, Franklin, common spelling. When the officer arrived to the hospital, the victim told the officer she was in a verbal dispute with the defendant, and he began striking her several times in the face. The victim then stated she believed she passed out, and that's when the defendant stopped. The victim sustained a black eye and bruises to her face and neck. And Your Honor, at the hospital, the victim her eye was being tested for possible loss of vision. The defendant pled guilty a year before this incident regarding that battery, reckless conduct to this very same victim. He was told to have no contact with this victim, yet here he is today with another charge against her. He is a violent offender, Your Honor. He has multiple victims in his history, so he is a danger to the community. He has a significant risk of intimidating this victim. And there has been no change in circumstances. And Your Honor, the DA's office has accepted this case. So we are asking that bond to remain as set. Nothing further.
All right, thank you. Sorry. Ms. McLean, you can proceed.
Your Honor, his main point about the bond situation was that it went to a certain address, and he had, on a timely basis, he had given a new address. I checked in the Odyssey, and the dates have to do with what day he did change the address. But his main point is that he is simply saying to the court that he sincerely did not intend to miss court, and he didn't have notice of the court date that he did miss. So he'd like to be reinstated in effect, not literally reinstated, but to have a signature bond to do the equivalent effect.
And of course, we would object due to the facts I stated earlier.
All right, bond will remain as set at this time. Is there anything further from my attorney?
Nothing further from the state.
Nothing further at this time, Your Honor.
All right, best of luck to you. Who do we have next?
Position 1 and 2 at South Annex, Your Honor.
All right, so position 2, I'm gonna have to enter the order that dismisses that case. So we're really here for position 1, case 21 CR 00796Y, in which defendant is charged with battery with the offense date of March the 30th of 2021. What is the announcement that we have for that case, Mr. McLean?
Brittany Anderson is announcing not guilty, and she is requesting a bond herself as well, Your Honor.
All right, would you like me to arraign the case, or will you also enter that waiver of arraignment for me? Ms.
We'll do that written waiver. I'll get that in a form by tomorrow.
All right, thank you. Ms. Sari, please give me the state's position on bond.
Yes, Your Honor, the state's position is to object to any modification of bond. This defendant does have a 2012 battery family violence. I wasn't able to find a disposition on that. A 2019 inflicting pain on the elderly and battery. She has 2 FTAs for this very same case, one in April and one in August, and they were plea and arraignment calendars. And further, Your Honor, a rule nisi order was entered regarding the defendant's FTA. So this matter was heard before a judge and a bond was revoked. Briefly with the facts, the defendant and the victim, whose name is Leon Martinez, they were acquaintances, and the victim received a call from the defendant asking to come to his home. The victim did permit the defendant to come over. And when the defendant propositioned the victim for intercourse, he said no. The defendant then got upset. She struck the victim in the neck and chest, and then she threw a bicycle lock at the victim. The state's recommendation in this case is 12 months to serve 30 days, credit for time served 11 days, the balance probated, an 8-week anger management course, stay away from 150 10th Street Northeast in Atlanta, and no contact with the victim. Nothing further.
All right, what is the amount of the current bond? I know it's a cash bond, but do you know what it is? Does anyone know?
Yeah, I have a 10,000 surety.
I have 10,000 cash, is that? That's what it's saying. Yeah, I see 10,000 cash. Okay, all right, Mr. McLean?
Your Honor, she would like to ask the court to consider a signature bond. She will be far more careful. It was inadvertent, as the phrase is, and she will be far more careful in making sure that she does not miss a court date. This is something that is the top of her list and top of her mind now.
All right, I just want to check one thing. Hold on a moment. All right, based upon the information before me, the bond will remain as set by Judge Edie at a $10,000 cash bond. Is there anything further from either party?
Nothing further, Your Honor.
Nothing at this time.
All right, best of luck to you. Who do we have next?
16 Lyman,
I'm sorry, say that name again.
16 Lyman.
Thank you. Good morning. Your case is 22 CR 001708Y, in which you're charged with battery, family violence, and criminal trespass with the offense date of January 23rd. Do you understand your rights today?
Yes.
All right, the announcement I have a negotiated plea. Is that still correct, Mr. McLean?
That is a negotiated plea, Your Honor, yes.
All right, Ms. Sally, very briefly, the factual basis and the state's offer.
Yes, Your Honor, the state's offer is 12 months to serve 365 days, credit for time served 203 days, and with the 2-for-1, there is no balance. Stay away from the incident location, 419 Lucky Street in Atlanta, and no contact with the victim, whose name is Gala, Gala, last name Hamilton, common spelling. Briefly, the facts are that officers responded to the incident location where the victim informed them that the defendant, who is the father of her children, came to her apartment to pick up one of their sons. The defendant then grabbed the child by his hoodie, and the victim pulled the child back. And that's when the defendant punched the victim in her face. She sustained injuries and her glasses were broken. Nothing further.
All right, Mr. McLean, was that your understanding of the offer? And do you stipulate to factual basis ID and venue?
We do, and it is our understanding, yes.
All right, Mr. Lyman, please raise your right hand. Do you swear in the affirmative testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yeah.
Did anyone force or coerce you into taking a plea today?
Yes.
They forced you to take a plea?
No.
Okay, and you said no one promised you anything in exchange for taking a plea, correct?
No.
And you understand that by waiving your right to a court date, you're not gonna have any more opportunity to prove any evidence you may have had to result in the dismissal of this charge, Mr. Lyman?
Yes.
And you're prepared to give up all rights to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right, as the charges are previously listed, how do you plead?
Yes.
I accept your guilty plea. If there's nothing further, that concludes Mr. Lyman's case.
I'm sorry, Your Honor, I would just want to add on their third-party transfer of the children, since they do have children together and the no contact is being put in place.
Okay, let me clarify. Originally, it was just a time served, so now you're also asking for the no contact. Is that what you're understanding too, Mr. McLean?
Well, that's new. We understood the time served part, Your Honor.
Right, okay, so is the plea now non-negotiated?
Let me ask, let me go into breakout with him and see if he understands exactly the requirements.
I apologize.
Okay.
No problem.
All right.
He said he understands, Judge.
And wishes to take the plea still? Just answer this very brief question. Do you all have children together?
We have 4 children together, and I understand no contact, and on third party, wanted to rent.
Okay, you understand that, and you wish to take the plea?
Yes.
All right, so we will add the note, what is the name of the victim, Ms. Ari?
Third party?
Her name is Gala, Gala, last name Hamilton.
Okay, so he's have no contact with Ms. Hamilton, and he will arrange to transport of his children through a third party.
Thank you.
All right. All right, is there anything further?
Nothing
I
further.
don't believe so.
All right, Mr. Ryland, best of luck to you, sir. All right? All right, who do we have next?
10, Dixon.
All right, good morning. Your case is 21 CR 003525J. And what you're charged with battery, substantial physical harm with the offense date of July the 16th of 2021. Do you understand your right here today?
Yeah.
All right, the announcement I have is that this case will be arraigned. Mr. McLean, will you enter a waiver of arraignment?
We'll do that by tomorrow. I'll get that form in.
Is there anything else outstanding as it pertains to this case?
I believe that bond is practically moot at this point. We may change that in the future.
All right, so the case will be reset for jury trial. Mr. McLean will enter his formal waiver by tomorrow. I don't believe there's anything further, Mr. Dixon, so best of luck to you. Please stay in contact with your attorney. All right?
Position number 28, 3 South.
All right. Good afternoon, I'm sorry, good morning. Good morning, Mr. Trombetta. Your case is 21 DF 007616D. You're charged with failure to maintain lane and DUI, each with the offense date of March the 11th of 2020. Do you understand? You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney here today, and this proceeding is being recorded. Do you understand all of that?
Yes, ma'am.
All right, thank you. Ms. Helen, the announcement is that this case will be arraigned and you're conducting a bond hearing.
Yes, Judge.
All right, and I don't suppose you'd be willing to enter that formal waiver, would you? Or are you asking that I arraign it at this time?
Yes, Judge, I'd like it arraigned, Judge.
All right. Just trying to move us along here, but I understand. All right, at this time, Mr. Trombetta, you've been charged with failure to maintain lane or improper lane change and driving under the influence of alcohol with the offense date of March the 11th. Ms. Helen, do you waive a formal reading of the accusation?
I do, Judge.
All right. At this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom the case is assigned. At this trial, Mr. Trombetta, you do not have the burden to prove the charges against you. The state, represented by the Solicitor General, bears that burden. However, if they meet that burden, you can face a fine of up to $1,000 for each charge, or up to a year in prison for each charge, and those can run concurrently or consecutively. Based upon this information I've presented to you this morning, how do you plead?
Not guilty.
I accept your not guilty plea. Mr. Tully, if I could have the state's position regarding bond.
Yes, Judge, there is a current bond set for $3,500, and that's a surety bond. That is $1,000 for the failure to maintain lane and $2,500 for the DUI. And Judge, the state would like for that to remain the same. The state's offer for count one, failure to maintain lane change, is 12 months to serve, 16 days, credit for time served, 8 days, balance probated. For the DUI, less safe, 12 months to serve, 16 days, credit for time served, 8 days, balance probated, completion of a risk reduction course, random screenings, alcohol, drug and evaluation treatment, a $500 fine, and no driving. Judge, on March 11th, 2020, at 1:52 p.m., the officer noticed the defendant failed to maintain his lane. The defendant swerved over into the bicycle lane in a rapid motion and swerved back into the lane. The defendant then slowly swerved into the right side of the roadway, which had he did that 2 additional times. As a result, the officer pulled the defendant over. The defendant showed signs of impairment due to having droopy eyes, slurred speech, uncontrollable convulsions, and more. Judge, the state is concerned that this defendant runs the risk of reoffending. He serves as a flight risk, and he is a danger to the community due to his criminal history. Judge, he currently has an open case for DUI, less safe, reckless driving, and failure to maintain lane, which he picked up with the disposition date, Lord God, he picked that up actually prior to this current case. He also has a DUI, less safe, open case, which he picked up after this current case, and that's in Judge Edeline's courtroom. And as a result of his he has 3 DUI cases that are open. The state would like for that bond amount to remain the same, which is a $3,500 surety bond.
All right, thank you, Mrs. Tully. Ms. Helen, your client is not interested in that offer at this time?
He is not, Judge.
All right, and he's requesting a full jury trial at this point.
He is, Judge.
Helen, your position regarding his bond?
Yes, Judge. Can I have pretrial give me the dates on those DUIs or his last 10-year history?
Ms. Harrison, can I have the history, please?
Judge, I have open cases for, 1 moment. The open cases are 21 CR 000761D. And that was offense date November 14th, 2019, and 21 CR 001013D. That offense date was 3/24 of 2020. Also, Odyssey indicates that this current case is in a dormant bench warrant status.
Okay.
Correct, Judge. So I have Mr. Trombetta here for 2 FTAs. I do hear the other open cases, but Mr. Trombetta has 2 FTAs in this case in which that warrant was served on him, Judge. I do hear his history, Judge, but this is not a violent offender. He's 67 years old. He is a Fulton County lifetime resident. He does have a very successful construction business, Trombetta Construction Service, that he's been running for the last 42 years, Judge. So just to look at the Ayala factors, again, I hear the open cases, but he's here for this case for failing to appear. So I do believe he will appear to all other future court dates. He understands how the seriousness of this case, Judge. So we are asking for a signature bond in the same amount, a $500 signature for the failure to maintain, and a $2,500 signature for the DUI, Judge. He also is suffering from cirrhosis of the liver. He has a large amount of fluid that builds up. And so with him being in the jail with that kind of medical condition, Judge, he believes that his life is in daily jeopardy of disease and also violence, Judge. So we are asking for that bond modification of a signature bond in the same amount.
All right, bond will remain set at the $3,500 surety. Is there anything further?
No, Judge.
All right, that's so much to Mr. Trombetta. Who do we have next?
Position 15, South Annex.
All right. All right, good morning, Ms. Lucky. Your case number is 22 CR 006. Oh, someone please mute. 22 CR 006712E, in which you're charged with theft by shoplifting with the offense date of September the 30th of 2022. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney at this proceeding today. This proceeding is being broadcast over the internet. It's also being recorded. Do you understand all of that today?
Yes, ma'am.
Do the announcement, Ms. McLean. You're muted.
Sorry, Your Honor. Yes, that's the negotiated plea, yes.
All right, will it be a negotiated plea? Ms. Sarah, please, very briefly, the factual basis and the offer.
Yes, Your Honor, the offer is 12 months to serve 16 days, credit for time served 8 days, the balance probated, an anti-theft course, and stay away from the incident location, which is Walmart at 844 Cleveland Avenue in East Point. The facts are that officers were dispatched to the incident location regarding a theft. Loss prevention stated to the officer that he observed the defendant concealing multiple items from the store into a backpack and attempted to walk away or walk out of the store. And the subtotal of those items were $387. Nothing further.
All right, thank you. Ms. McLean, was that your understanding of the offer? And do you stipulate to factual basis, ID, and venue?
It is our understanding of the offer, and we do so stipulate.
All right, thank you. I'm gonna ask you some questions, Ms. Lucky, to make sure this is the voluntary plea. Will you please raise your right hand?
Yes, ma'am.
All right, you're under the influence of any drugs or alcohol? I'm sorry, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
Hey, put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force or coerce you into taking a plea?
No, ma'am.
And you understand that by taking a plea, you're not gonna have any other court dates regarding this charge?
Yes, ma'am.
And you're prepared to waive your right to have the state prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements that you cannot go back to Walmart, but otherwise the time that you served at the Fulton County Jail should close out your sentence?
Yes, ma'am.
After the charge of theft by shoplifting, Ms. Lucky, how do you plead?
Guilty, Your Honor.
I accept your guilty plea. Is there anything further from either party?
Yes, Your Honor. We wondered, can the court give her, could the court be kind of give her a financial break on the first 2 months of probation and allow it to go to non-reporting once she finishes that class?
Yes, she waived the first 2 months of fees to give her time to take that class. Once she's completed the requirements, you can go down reporting. All right, is there anything further?
Nothing further.
All right, best of luck to you, ma'am. Who do we have next?
I have position, add-on 2.
All right. Will you pronounce your name for me? All right, ma'am, your case number is 22 CR 006494A, and what you're charged with criminal trespass and damage to property with the offense date of September the 25th. Do you understand your rights today? You have a right to remain silent. Anything you say can and will be used against you. You have a right to an attorney, and this proceeding is broadcast over the internet. Do you understand that? You understand? All right, thank you. All right, and what is the announcement for this case?
Judge, we're requesting a bond hearing.
All right, and we're gonna arraign this case.
Yes, Your Honor.
All right, at this time, I'm gonna be, all right, ma'am, you, in the case number I just listed, you've been charged with criminal trespass and damage to property, which has been formally accused by the Solicitor General. Ms. Helen, do you waive the formal reading of the accusation?
I do, Judge.
The case will be set for trial, and the trial is scheduled by the state court judge to whom the case is actually assigned. You do not have the burden to prove those charges against you. The state represented by the Solicitor General bears that burden. And if they do get a conviction against you, you could face a fine of up to 1 year, a fine of up to $1,000 or, I'm sorry, 1 second, hold 1 second. I'm sorry. I'm hearing that this case has been previously arraigned. Has a social worker gone to see the defendant? Judge Morrow instructed that a social worker was supposed to see her before any modifications were made to her bond. Has that taken place?
Judge, I don't have notification that a social worker has visited Ms. Yamini yet.
She's not yet. The social worker came to see you. Do we have results of that? So you don't even know what the social worker said, Ms. Ellen, correct?
I do not.
Okay. Hold on one more second.
Judge, good morning, Judge. I can reach out to Miss Mean Williams. I believe she's the social worker that saw Miss Yamini. So let me see if I can get her to.
Okay, and I want to, so I guess we'll come back to this case, because I think Judge Morrow had some specific instructions that I'm gonna read now.
Okay.
Thank you, Judge.
Yes.
Position 11, Mr. Peterson for the competency.
We're not quite ready for competency. I haven't had a chance to speak to Mr. Howard, Mr. Walker yet. So if we can finish the other positions on state on purpose first.
I have, position 1 on the probation. Would you like to take her?
Yes, I'm ready.
I can do that one.
Yes, ma'am.
All right, where is my probation? Is probation on the line? Oh, maybe we can't take it. Is anyone from probation on the? Where I can come?
Good morning, Judge Williams. How you doing? This is Ms. Harris.
Good morning, Ms. Harris. Officer Harris, I'm gonna place you under oath and the defendant in a moment. Give me 1 moment.
Yes, Your Honor.
Ms. Anderson, your case is 17 CR 00762H, in which you're charged with battery family violence with the offense date of January the 24th. Do you understand your right to here today?
Yes, ma'am.
All right, at this particular hearing, what's gonna happen is I'm gonna hear from probation, and then I'm gonna hear from your attorney. And we're gonna determine whether you're gonna be allowed to continue on your probation or whether or not you've met the requirement by serving time in the Fulton County Jail. I'm gonna ask that both Officer Harris and you both raise your right hand. Do you swear in affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, thank you. You can put your head down. Officer Harris, please proceed with your recommendation.
Yes, Your Honor. Ms. Anderson was sentenced to probation on July the 11th, 2018 of 12 months to complete a domestic violence program. As of today, she did not report to our office, and that's why a warrant was issued for her arrest. She has 7 months and 16 days remaining on her case. Probation recommendation is to continue on her probation. And within the next, since that class does take 6 months to complete, probation's recommendation also is to have her enroll into those classes within 30 days.
Right, she would have to, or else she would not have time to complete, correct, Officer Harris?
Yes, Your Honor.
All right, Ms. Anderson, do you understand? Ms. Allen, before I go to Ms. Anderson, your recommendation and your understanding?
Yes, Judge. My recommendation is to follow probations to have Ms. Anderson report within 48 hours. When I spoke to her, she stated that she suffers from sickle cell anemia and she is in and out of Grady Hospital due to that disease, which makes it very hard for her to make it to these probation dates. But Judge, she understands that she does need to report to 132 Mitchell Street, Southwest Atlanta. I have an up-to-date address for her, a 1990 Willow Trail Parkway, apartment 130, Norcross, Georgia, and up-to-date phone numbers, Judge. So we won't have any issues of her not appearing to probation or doing the conditions, Judge.
She does have stable address, no concerns about her residency, Ms. Helen?
No, Judge, I have a stable address and 3 separate phone numbers.
All right, wonderful. All right, at this time, what will happen, Ms. Anderson, is I will report this as a probation violation, but you'll be allowed to continue on probation. You'll need to report the probation within 48 hours, and you'll need to complete the requirements of that class. You understand that?
Yes, ma'am.
All right, if you don't have any other holds, I believe you'll be released from the Fulton County Jail shortly. All
Thank
right,
Yes, ma'am.
all right, make sure you take that class, all right?
Yes, ma'am, no problem.
Thank
All
you, Judge.
Thank you. Best of luck to you all. All right, is that?
I'm sorry. That concludes my business. May I be excused and can I bring the documents to the chambers?
Yes, thank
All
you.
right, I see Your Honor. Thank you.
Shortly. Does that conclude state all-purpose? I believe there are 3 positions that I see remaining. Is there an announcement for position 3 and 4, Mr. Mario Berry?
Oh, we got him. 3 and 4 was recent, Judge.
3 and 4 is
Wonder by coincidence, I'm on the phone. 3 and 4 was that reset.
okay, yes. And position 12? What reset 5? Reset is 5 to 10:20. Is there an announcement for position 12? The
Yes.
private attorney.
I had a notion that Mr. Sam Rail was representing her on this matter. Is that correct or incorrect? 'Cause
I see private attorney here. Is Mr. Rail present on this Zoom conference?
He's not present, but I did talk to a colleague of his, someone who answered his phone yesterday, but was not an employee of his office. And he was familiar with the name. And that gave me indication that if he's familiar with the name, then probably there's been something going on. Mr. Sam Rail was, I believe, listed in Odyssey. I'm not sure it's on the same case number, so it's confusing. And
All right.
I intend to follow through.
Is Ms. Hill at the South Annex now? No,
She is here, but I was just waiting to see if I needed to bring her or not.
And there's no answer from that.
She does have some issues, Your Honor, that
not to, as to this case, we're not seeing that attorney enter. He may be entered on another matter. Mrs. McLean, is your office willing to, could she, I guess we probably would still need to reset it. You need time to interview her, correct?
Well, actually, I've already interviewed her last week, but I believe it is worth following through on Mr. Rail because it seemed logical that considering the structure of the family, it appeared to me that perhaps the parent had hired him. I wasn't sure. She does have some issues that would indicate that would be logical.
All right, so Mrs. McLean, you're asking, or you think it prudent here to reset this case 1 week? You're gonna
Yes, Your Honor.
come to Mr. Real. All right, I believe we concluded state on purpose. Ms. Grace, if you would review the calendar and then I can go into breakout with Mr. Howard and Mr. Walker so that I can begin the competency calendar.
So we reset in position 12.
Yes. 1 week.
Okay, position number 1, reset jail jury. Position number 2 was a dismissal. Position number 3 and 4, reset 10/20/22 SAP. Position number 5, reset 10/20 SAP. Position number 6 was a plea. Position number 7, reset further notice. Position number 8 was a plea. Position 9 was a plea. Position 10, reset jail jury. Position 11, reset further notice. Position 12, reset 10/20 SAP. Position 13, reset 10/20 SAP. Position 14, reset 10/20 SAP. Position 15 was a plea. Position 16 was a plea. Position 17, reset jail jury. Position 18, reset 10/20 SAP. Position 19, reset further notice with the amended bond order for Ms. Helen. Position 20 was a non-pros. Position 21, same defendant, was a dismissal. Position 22, reset 10/20 SAP. Position 23 and 24 were pleas. Position 25 was a plea. Position 26, reset jail jury, amended bond order. Position 27 was arraigned, reset jail jury. Position 28 was arraigned, reset jail jury. Position 29 was a plea. Position 30, reset jail jury arraigned. Position 31 and 32, reset 10/20 SAP. Position 33, reset jail jury. Position 34, we said jail jury. Position 35 was a plea.
Any comments, changes, corrections, or questions?
Judge, we're holding on Miss Yamini, position add-on 2. We're just holding to see if she can actually get confirmation to be placed in a women's shelter. So we're just waiting for some more information on her case, okay?
All right, we'll continue to hold on that case. Everyone else who was here only for state all purpose is free to go. Those who need to remain for the competency or that add-on 1, unfortunately, will have to remain here on the calendar with us. Mr. McLean, if you intend to bring orders from oh, he's on the phone. Mr. McLean, though, I'm gonna, Ms. Grace, we chat him later. I'm gonna ask that anyone who needs to bring paperwork physically to me in the courtroom, start doing so. Usually Mr. McLean makes that election. If Mr. Howard, it could be placed in a breakout with me and Mr. Walker as well, and Ms. Burgess, so we can begin the competency calendar.
courtroom too? Is Mr. Gonzalez in that courtroom?
Yes, he is.
Okay, I'm about to add you guys to the breakout room with the social worker and the interpreter.
You can sit in the third row. Come on, Mr. Gonzalez.
Do y'all still need probation? Intake?
I think it's position number 2 they're holding on. I'm not quite sure.
Okay, no problem.
Okay.
But you know, one of them. We told you, told the officer, they don't wanna. Yeah, we told the officer, we need to get charged on that, maybe. And we're, Department of Labor, Department
All right, we're all back for the competency calendar. We've discussed cases in breakout. Is courtroom 2 on the line? But there was still one state all purpose case at courtroom 2, and has Ms. Burgess returned from the breakout with the court reporter. That might be what's happening at courtroom 2, that breakout is still taking place, so we're not done.
And
All right.
add on position 2.
Right, right. All right, who we have in South Annex?
This is position number 10 on the competency calendar, Ms. Minor.
All right, Ms. Minor, your case, I discussed with your attorney is present. Your case is 22 CR 003804A, in which you're charged with battery family violence with the offense date of June the 13th of 2022. After hearing arguments from your attorney and the state, what's going to happen is you currently have $1,000 good bond in place. That $1,000 good bond will convert to $1,000 signature bond with the condition that you are to have no contact with the alleged victim in this case. I understand that you have another hold for a different case in another county, so you will likely be released to that hold. If you have questions, the best person for you to speak to about this is your attorney, Mr. Howard. All right?
Yes, ma'am.
And
All right.
yes, and I would ask if South Annex, if I could, I'm gonna call when I'm released so that I can explain something to her about the contact.
Yes, sir.
All right.
Thank you, Judge.
All right, that concludes Ms. Minor's case. Best of luck to you, ma'am.
Thank you, Judge.
All right, thank you. All right, we are still holding on. Who is this? Who is that? 3 South?
Mr. Campbell, position 5.
All right, Mr. Campbell, at this time, your case is gonna be reset. I've spoken with your attorney. There's further development that needs to take place with your case, okay? So your attorney's gonna give you a call regarding your case, okay?
Donald Campbell, Donald Steve. I'm
Sorry, Mr. Campbell, I can't hear what you're saying.
Your Honor, my name is Donald Allen Cameron. This is
Yes.
Campbell, Donald.
Okay, I understand, Ms. Campbell. I don't want you to tell me too much about your case. I'm just letting you know that your case is gonna be reset and your attorney is gonna speak with you further, okay?
Okay, thank you, ma'am.
All right, you have a good day, Mr. Campbell.
Okay, thank you, ma'am.
All right, thank you. We'll be on hold for courtroom 2 and that add-on case.
She left already. Judge, can you hear me?
Yes, I can.
Do you need position 13 and position 6 on 3 North?
Mr. Howard, are you still here? Are you still asking that those positions be brought so that you can speak to them briefly? Is Mr. Howard, just hold one moment for me. Mr. Howard, are you still asking to see position 6? That was the gentleman who's gonna be reset.
Yes, Mr. Fennell, is he there? We need to just express to him about being available for the interview. Where's Mr. Gerard Fennell? He needs to be brought.
Can he be brought very quickly?
He's on a different floor. We can go get him though.
Okay, we're gonna
Yes.
hold just to let him know that information, please.
Okay,
Thank you.
you're welcome.
Are we able to take the add-on case by any chance? That was on.
The add-on case, I think, is in courtroom 2, and they're in the breakout with the Spanish interpreter.
They're in the breakout. Okay, thank you, Ms. Champion. I was trying.
Ms. Champion, can you put me in that breakout with Ms. Burgess and Mr.?
Yes, Derek, I put you in.
All right. Your Honor.
I'm ready, yes.
Yes, Your Honor, we spoke with position 2. Ms. Ayala Gonzalez explained everything to him and the reset date, as well as Mr. Peterson is aware of what we discussed in terms of him being released next Wednesday. So if the court is comfortable, we don't need to see either of them if you're okay with them being sent back.
That's fine, yeah.
Okay, all right.
So, position 2 is gonna be reset and the other 2 cases in the courtroom. So your courtroom 2 is completed, Mr. Howard?
Yes, I believe they're finished with all the people they have there.
All right, courtroom 2 can be excused. We're gonna just wait. We're still waiting on, position 6 though, correct?
Yes, that's correct, Judge.
All right, and what about that add-on case? Well, courtroom 2 is not completed, is it? That add-on case from the, state on purpose position.
She's here, Your Honor, South Annex.
Oh, she's in the South Annex. Okay, so courtroom 2 is completed. Have a good day. Take care, everyone. Bye-bye.
Thank you too.
All right, back to South Annex for that case, if possible. Is Ms. Helen still here?
Yes,
I am, Judge.
Is that
All right.
Ms. Yamini?
Yes, Derek, it is.
I'm sorry, 1 second. Ms. Grace, I'm sorry. Can I see that order? Remember Judge Morrow said that something needed to take place? That the state on purpose add-on case, the one where the social worker had to go out.
Right.
Okay.
Judge, but it's written on the front, so you want me to reset him to
Say like 2 weeks.
next 27.
Does anyone recall what it was that Judge Morrow was requiring? Does the order is not in?
Yes, I recall. So I think Mr. Tola is on the line.
Yes, Your Honor. He was requiring, I believe, a social worker to go out and speak to Yamini before he proceeded.
Right. And Judge, I've heard, I just want to provide an update related to that. Miss Amin Williams did go out and see her yesterday, and she also contacted City of Refuge, the women's shelter that we've sent other women to, and they do have availability today. However, realistically, she wouldn't be able to get, even if the court were inclined to release her to that, wouldn't be able to get released to that today. We anticipate that, it's a situation where you have to call each day. So we would ask the court for maybe tomorrow tomorrow is Friday. So tomorrow for her to be released to City of Refuge. She's indicated she's not wanting to enter a plea to the charge. She's concerned about, a couple of different reasons she doesn't want to enter a plea to the charge. But we would ask that she be released to that program that could provide her with the housing, the temporary housing she was seeking, and it is a women's only shelter. So that would be our request.
Okay, Mr. Tola, if you would give me very briefly the factual basis here and the state's recommendation and response to Mr. Howard's request.
Yes, Judge. So the factual basis is on September 25th of this year. The police were dispatched to the incident location in reference to a domestic dispute. The victim advised 911 dispatchers that his ex-wife was refusing to leave his home. When an officer arrived, he made contact with the victim, and after speaking to him, they determined that her, which is the defendant, and the victim were married in India, and the victim obtained a divorce in the United States, and that the defendant did not reside at the victim's home. The officer asked the defendant to leave several times, but she stated that she wanted to get arrested and that she needed to escalate the situation so people would know what the defendant did was wrong. The defendant refused to comply to officers' commands by leaving, and eventually she was arrested. The state's offer is time served 18 days, stay away from the incident location, 5102 Woodland Lane, Alpharetta, Georgia, 30009, and no further contact with the victim. Karthikeya Kenda, I can spell it for you, Your Honor. The first name is Karthikeyah. Last name is K-A-N as in Nancy, D as in dog, A-S-A-M as in Mary, I.
Okay, and the state's position regarding changing her good bond to a signature bond?
Judge, the state will not object to that. We'll consent to amending it to a signature bond so long as she has a shelter, in fact, to go to, because that was Judge Morrow's main concern. And considering her lack of criminal history, she doesn't have any cycles, the state wouldn't mind consenting to a signature bond.
Okay, and so what my concern though, Mr. Howard, is if I did the signature bond and will tomorrow be enough time, I guess is really my question.
And what we can do, Judge, and we sort of had this come up before, if we can do it for tomorrow, and it would be a release to our investigator as well as the social worker to actually transport her there. And if for some reason they don't have availability, we may need to come back on, on Monday and do the same thing, which we've had to do for other clients when they don't have it that day. So that would be our request.
You will bring her back where? Fulton County Jail?
Well, what they'll do is before they take her, they'll confirm that she can go there. But if it turns out that they can't get her in tomorrow, then we'll have to, and the jail usually will work off of that same order. But if they need another one, we can submit another one for Monday if they can't, get her up there tomorrow. But they have availability today. It's just she wouldn't get out in time because they have to be there by 3 p.m.
Okay, all right, understood. So we will convert that to a signature bond based on the information before me. It'll be $1,000 signature bond. She'll be released to the investigator, who will therefore transfer her to what was the name of the location again, Mr. Howard?
City of Refuge.
City of Refuge.
Yes, a women's.
All right. Is there anything further regarding this case?
Nothing further from the state judge.
All right, that will conclude your case, ma'am. Best of luck to you, and I believe South Annex is complete?
Yes, ma'am, that'll be all.
All right, you all can go to lunch. Take care.
Ms. Goffin, I'm gonna call that number if you can let me speak with Ms. Minor briefly.
Yes, sir.
All right.
All right. Who do we have at, I think it just says Fulton. Is this position 6?
Yes, ma'am. Yes, ma'am.
Mr. Fennell is here. Mr. Fennell, your case is gonna be reset 1 week. You're gonna undergo an interview, all right? I wanna make sure that you participate in that interview. And Mr. Howard is also gonna give you a call. Please engage with him to obtain the information you need to process your case, okay?
Mr. Fennell, are you able to get in and out of your cell okay?
Nope.
You're not?
Nope, I'll be all right.
Well, we're gonna make sure that you can get in and out of the cell because we're trying to find you a placement, but you got to talk with the people on the phone. So I'm gonna come and see you, so we can get you interviewed, so we can work on getting you out.
Will you speak to Mr. Howard when he comes to see you, Mr. Fennell?
I don't want to speak to nobody no more.
I understand you don't want to, but I think it's in your best interest so that you can actually move towards getting out of the Fulton County Jail and getting some resolution to this. The best and really the only way for you to do it is to speak with Mr. Howard. Would you consider doing that?
No, I'm straight.
So when Mr. Howard comes, you won't.
Still gonna come.
Mr. Howard is still gonna come. Are you gonna refuse to come out of your cell and speak to him?
No.
You're facing some serious charges. Again, I can't force you, and I'm not gonna order that you.
I ain't facing no serious charge. I'm facing the same charge. Y'all keep doing me to run around. Y'all grab me up.
I don't want you to say too much about the charge.
Street for that, so I ain't worried about it.
Okay. Well, Mr. Howard is still coming. It's my hope that you'll actually see him, okay? It is your right to not see him, but he's coming to see you, and I strongly advise you to actually speak with him, all right?
All right. And Judge, could I get a number for the deputy there at where Mr. Fennell is? Can I get a phone number to call you?
They trying to charge me with stupid stuff.
There's no number where we at now, but we're gonna return him to 3 North.
Okay,
is there a number for 3 North?
Yes, but I don't have it on me right now, but I can.
I had walked off on my hotel, so I do wrap me up in the infantry charge.
Is there a number I can call you?
Like a cop.
Yes.
I got it.
Okay, we got it.
Okay, all right.
Mr. Howard, were you asking to see anyone else?
No, I just need for the deputy to call me, but no, I don't need to see anybody else.
What about Thornton, Bennett Thornton?
Oh, okay, we're gonna
see Mr. Thornton.
Yeah, to the next. What's your name, Mr. Judge?
I do believe, don't we need to see Mr. Thornton as well? Was that your request, Ms. Howard?
if we're gonna do next week, no, Judge, then we can do it then. I was hoping he would be released today, so we can reset. I can see him next week.
All right, well, that will conclude the calendar. Ms. Grace, will you review the competency for us? Position number 1, reset further notice. Position number 2, reset 1027 competency calendar. Position number 3, reset 1027 competency calendar. Position number 4, reset 11-3 competency calendar. Position number 5, reset 1020 competency calendar. Position number 6, reset 1020 competency calendar. Position number 7 and 8, reset 11-10 competency calendar. Position number 9, reset 11-3 competency calendar. Position number 10 is going to be reset further notice. Order released to Spalding County. Position number 11, reset 1027 competency calendar per Mr. Jordan, just in case he's not released on the 19th, Judge. All right. Position number 12 is reset 11-3 competency calendar. Position number 13 is reset 1020 competency calendar. Position number 14 is reset 11-17 competency calendar with ASG considered an all-pros. Position number 15 is reset 11-10 competency calendar. Position 16, reset 11-27 competency calendar. Position 17, reset 11-10 competency calendar. Any comments, changes, corrections, or questions? All right, hearing none, we'll be in recess until the state of calendar on Tuesday, at which time tomorrow will be presiding. Everyone take care. Have a great rest of your afternoon.
Thank you.
All right, bye-bye.
Thank you, Judge.